This is Justice, History, and the Law. Lectures, discussions, and interviews from the Robert H. Jackson Center in Jamestown, New York.
Ladies and gentlemen, at this time I'd like to introduce Professor John Barrett.
Thank you very much, and good morning. Welcome to Chautauqua Institution and to this wonderful event sponsored by the Robert H. Jackson Center. What I'm here to do is a brief introduction and a bit of backdrop to get you oriented to the events that culminate, but really only begin in a certain sense with the Supreme Court decision 50 years ago. One of the legal institutions that grew up is segregation, division of races by law at state, local levels. And so many states had laws that now required, despite the Civil War, despite the abolition of slavery, despite the enactment of an Equal Protection Clause, passengers to ride in separate rail cars, for instance, by race. Whites up here, Negroes back there. That segregation was challenged in a case that rose to the Supreme Court and was decided in 1896. That case was called Plessy versus Ferguson. And in that case, a majority of the Supreme Court interpreted the Constitution, including the new parts, the repairs to slavery, as permitting segregation in the transportation context. Separate but equal requirements, said the Supreme Court in Plessy versus Ferguson, were just fine. Were consistent with the 14th Amendment. And if minorities, if American Negroes interpreted that as discrimination, as some kind of disparagement, well, the Supreme Court says that's just their problem. And that's where American law stood for more than the next 50 years, from Plessy versus Ferguson in 1896 up into the 1950s. And during that period of time, Jim Crow grew and flourished. And one of the areas in which it flourished was education, because states and localities began to get into the business of public education. States and localities providing public schools and requiring students to go and be educated up to certain ages. And in many states, the laws also said, you black students go to this school, and you white students go to that school. Now, this landscape of legal segregation, in a sense, is the return of the evil, the injury, the wound of slavery in a new legal form. Part of what begins to develop is slow progress at the national level. President Truman desegregated the armed forces in the late 1940s, and an organization called the National Association for the Advancement of Colored People, the NAACP, began to file lawsuits challenging segregation requirements in different contexts, in different localities all across the country. Transportation cases, school cases, public facility cases. The Supreme Court begins to decide some of those cases by late 1940s, 1950. Still the law of the land is separate but equal. Still the law of the land is Plessy versus Ferguson. But separate but equal, of course, permits something with a certain demand. It permits separation if what is provided is equality. And some of those early cases called the states, the segregating states, on their systems and said, you've got segregation, but you don't have equality. You have black schools and white schools, but guess what? You have good schools and dreadful schools. And some of those lawsuits are the first ones that rise to the Supreme Court. And the Supreme Court, by 1950, has decided that in the graduate school context, law school, and in Oklahoma, a case about a graduate school student in the education field, separation was never going to satisfy the equality part, and thus integrated facilities would be required. But that affects a small number of people, graduate schools and law schools. Many millions of people are affected by elementary and secondary education. And so the issue that is ultimately rising to the Supreme Court by the early 1950s is whether Plessy will continue to be the law of the land or whether the Equal Protection Clause requires the end of this segregation in the elementary and secondary schools of this country. That case is the Brown versus Board of Education case. It actually comes to the Supreme Court from many trials and appeals and is a grouping of 5 separate lawsuits. One is a case from the District of Columbia, and 4 others come from the states, from the state of Virginia, from the state of South Carolina, from the state of Delaware, and from the state of Kansas. What happened in each of those communities, states, and lawsuits was that brave parents agreed to be litigants, to be plaintiffs, represented by the NAACP, challenging the segregation system that assigned their children to certain schools and legally prohibited them from attending the so-called white schools. The cases come to the court in 1952, and it takes the Supreme Court 2 years ultimately to decide the cases. The first number of the 5 cases, the low number, was assigned to the Kansas case, Brown et al. Versus the Board of Education of Topeka et al. The families and the parents were a group of African Americans challenging the segregation policies that had sent their children to the black schools. The lead plaintiff, who gets his name on the case and creates the historical moment we're here to celebrate by this name, is Reverend Oliver Brown. He lived in Topeka. He had 3 children. He had 1 daughter in elementary school, another soon approaching, and there was a near school and a distant school. And the near school was the white school, and those children were not permitted there. They had to go to the more distant school. That oversimplifies it, but that's the gist of what his experience was. And he agrees to do a very brave thing, to put his name and to put his safety and his security and his children at some risk by going to court to fight this. And there's a trial in Topeka, and the judge makes some helpful findings, but generally they lose. And there's appeals, and generally they lose. And now that case plus the other cases from the other states come to the Supreme Court. And the Supreme Court ultimately gets it right on May 17, 1954, holding that separate but equal has no place in our country with an equal protection clause in public elementary and secondary school education. The Reverend Oliver Brown is no longer with us. But of course, he wasn't litigating for himself. He was litigating for education. He was litigating, and the other people litigating were litigating for their children. They were litigating on behalf of the individuals who they loved the most. And in his case, 2 of them are the women behind me on the stage. Linda Brown Thompson was the student already in elementary school. Cheryl Brown Henderson was soon approaching school. They, in a sense, are the winners of Brown versus Board of Education. But what they really did and what their brave father did, and all those litigants did, and the Supreme Court did, was for us. And so we begin this conversation today as a matter of history, but I assure you, we are all in the school today working on that education, which has always been the point of Brown versus Board of Education. Our first speaker will be Linda Brown Thompson. Thank you very much.
Good morning. Good morning. I know it's a good morning, especially for you students, because you got out of school this morning, right? It all started for me on a balmy day in the fall of 1950 in the quiet Kansas town of Topeka, when a mild-mannered black man took his plump 7-year-old daughter by the hand and walked briskly 4 blocks from their home to the all-white school and tried without success to enroll his child. The child of whom I speak was I, Linda Carol Brown, and my father, the late Reverend Oliver Leon Brown. Black parents in Topeka felt that the day of trying to enroll their children in the school nearest to their home was long overdue. Many were the evenings my father would arrive home to find my mother almost in tears, because I would get halfway to the school bus stop, which was a 7-block walk from my home. I could only make half that walk, because the cold would get too bitter for a small child to bear. I can still remember starting that bitter walk and the terrible cold that would cause my tears to freeze upon my face. I would return running as fast as I could. I had to cross a very busy avenue in order to catch the school bus, which would carry me more than 2 miles across town to the all-black Monroe Public School. These were the circumstances which so angered black parents. My father pondered why. Why should our children have to travel so far to school, facing unbearable winter weather, waiting for a badly overcrowded school bus to carry them some 2 miles across town when there is a school only 4 blocks from our home? Why? Why must I have to spend time trying to explain to my child that she cannot go to school with her neighborhood playmates, who are predominantly white, Native American, and Hispanic, because her skin is black? In the face of this discouragement, he, along with 12 other parents, met with the local NAACP and their lawyer, Charles S. Scott, a local attorney, to make plans for each family to try and enroll their child in the white school nearest their home during September 1950. After trying enrollment and being turned down, a suit was filed in federal court in February of 1951. During the following July, the federal 3-judge panel heard testimony from my father, along with several of the other parents, who agreed that segregated schools for blacks were unequal. I, along with my father, had to appear in court, but unlike him, I was not asked to appear on the witness stand. The case was argued before a 3-judge federal court in Topeka and was decided in favor of the Board of Education and its segregated elementary schools. In Topeka, the issue was not so much integrating public schools to improve the quality of instruction, but rather the inaccessibility of the neighborhood schools. Black people were able to live all over town, but could not expect to send their children to the schools closest to their home. As for the quality of instruction, we have to pay our respects to the black educators of the 50s because they set untarnished examples and they expected no less than our best efforts. And I might add that that wasn't only Monday through Friday when you saw those educators in the classroom, but that was also on Saturday afternoon when you saw those educators at the grocery store. Also, that was on Sunday morning when you saw those educators at church. You better be on your best behavior. During the local court battle, there was a very definite division within the black community. There were those who felt this action was long overdue, and those who expressed concern about upsetting the balance of things, which they feared could lead to job loss and threats of violence. The local school board, which somehow believed itself to be above reproach, mailed threatening letters to black teachers, the most well-known of which stated, and I quote, "Dear Miss Buchanan, due to the present uncertainty about enrollment next year in schools for Negro children, it is not possible at this time to offer you employment for next year. If the court should rule that segregation in the elementary grades is unconstitutional, our board will proceed on the assumption that the majority of people in Topeka will not want to employ Negro teachers next year to teach white children. It is necessary for me to notify you now that your services will not be needed for next year. This is in compliance with continuing contract law. If it turns out that segregation is not terminated, there will be nothing to prevent us from negotiating a contract with you at some later date this spring. You will understand that I am sending letters of this kind to only the teachers of the Negro schools who have been employed during the last year or two. It is presumed that Even though segregation should be declared unconstitutional, we would have need for some schools for Negro children, and we would retain our Negro teachers to teach them. I think I understand that all of you must be under considerable strain, and I sympathize with uncertainties and inconveniences which you must be experiencing during this period of adjustment. I believe that whatever happens will ultimately turn out to be the best for everybody concerned. Sincerely yours, Wendell Godwin, Superintendent of Schools. After the unsuccessful attempts in federal court, an appeal was made to the U.S. Supreme Court under the guidance of the NAACP legal staff, more specifically, the Honorable Justice Thurgood Marshall. At the Supreme Court level, the case was consolidated with similar cases and argued in terms of the psychological damage brought about by segregation in public education. Experts from the psychiatric community were pulled in to examine whether or not segregation, in fact, served to break a youngster's morale and block the development of a strong, positive self-concept so essential to educational progress. My family became lost in the turmoil of the ensuing years, years that scarcely touched us. We lived in the calm of the hurricane's eye, gazing out at the storm around us and wondering how it would all end. I don't think my father ever got discouraged, but at this particular time, neither I nor my parents knew how far-reaching this suit would become. During the next 3 years, while the now famous decision was in the making, my father was called into the ministry. He received a charge in the fall of 1953, and the family moved to the northern part of the city, where we became the first family of the St. Mark AME Church. I was transferred to the all-black McKinley Elementary School in North Topeka, again facing the same situation of having to walk twice the distance it would have taken me to reach the all-white school just 3 blocks from my home. Time stood still as the highest court of the land pondered over Brown versus Board of Education until an afternoon in May of 1954, when I was in school, my father at work, and my mother at home doing the family ironing and listening to the radio. At 12:52 p.m., the announcement came. The court's decision on ending segregation was unanimous. My mother was overwhelmed. On returning from school, I learned of the decision, which at that time meant only to me that my sisters wouldn't have to walk so far to school the next fall. That evening in our home was much rejoicing. I remember seeing tears of joy in the eyes of my father as he embraced us, repeating, "Thanks be unto God." That night, the family attended a rally given by the local NAACP and held at the Monroe Public School. The following school term was so very different, but not for me, because I was never to benefit from the now famous decision. For during the '54 school term, I entered junior high school, which was already on an integrated basis, as were the high schools in the city. The strange thing about the Topeka school system was that at other levels of public education, at least on the surface, it appeared to be integrated. Junior high school and high school students of all races attended the same schools, sat next to one another in class, but could not participate in the same school-sponsored extracurricular activities. There was a white athletic team, and there was a black athletic team. There was a prom and all-school king and queen for the white students, and there was a prom and all-school king and queen for the black students. During the 30s, our mother was elected all-school queen by the black students. So we say we do have some royalty in our family. Integration in the city in the fall of 1954 went very smoothly. It seemed as though blacks and whites had been going to school together for years. Neither I nor my family suffered the abuse or racial strife that marked integration in the latter 50s and early 60s in so many parts of the country. We were very fortunate, my father would often say. He believed very strongly that God would move people to do the right thing. The latter 50s found my family living in Springfield, Missouri, where my father held the pastorate of Benton Avenue AME Church. At this time, newspapers and magazines began to do follow-ups on me and my family because the significance of the Supreme Court decision which carried our name was beginning to really take hold throughout the country. It was during this time that I inherited much of the recognition that might have gone to my father had it not been for his untimely death in 1961 at the age of 42. If he had lived, I'm sure he would have become a strong civil rights activist in the movements of the 60s. Little did he know that years ago, when he stepped off the witness stand, he stepped into the pages of history. I didn't understand what was happening then, but it was clear that Brown versus the Board of Education was a necessary victory. It might have been a little flame, but it served to set off a mighty flame. Sometimes I wonder if we really did the nation and children a favor by taking this case to the Supreme Court. I know that it was the right thing for my father and others to do then, but after nearly 50 years, we find the court's ruling remains unfulfilled. There is still de facto segregation throughout much of the United States. The trouble does not stem from the fact that schools are not equal in their physical makeup, but the problem lies within the physical makeup of the inner city. The housing patterns are still causing us today to find predominantly all Black and Hispanic schools in certain areas. We witness every day the problem of urban renewal, the building of low-income housing in a neighborhood that is already 90% Black, thereby making the school of that neighborhood 99% Black. Opposition to school desegregation is neither new or novel, and it will continue to exist. Continued resistance to desegregating schools is symbolic and represents a core philosophy that America was founded on the principles that does not include its minority population. Quite literally, the right, whether exercised of Black children or any children, to attend public schools is a right that is crucial, not only to the success of people, but to the survival of this entire country. The majority of our population is growing older, and the young families giving birth to new generations are predominantly Black and Hispanic. With so much at stake, we cannot afford to surrender. Our efforts may or may not be successful, but fighting for survival is never a no-win policy. We need to be more concerned about what is being done in schools that teach most of our Black children in our communities. And as school district plans are made, how do we have meaningful input? And how does the community see that school district plans are actually carried out? Today, it takes a keen eye and ear to detect the subtle areas of discrimination because it has become a matter of economic segregation. This type of disparity is what prompted a renewed look at Topeka in what was called Brown III. We must be mindful of delivering effective education. To me, The impact of Brown is best seen in the increasing numbers of Black professionals today. These are the people that after 1954 were able to have some degree of choice. This surely made a difference in their aspirations and their achievements. I ran across a quote in a new book by one of our Black women authors. Her name is Mildred Pitts Walters, that I believe says it all. It is not the treatment of a people that degrades them, but their acceptance of it. Thank you.
Well, good morning once again. I want to begin by thanking the Jackson Center for this opportunity to be here. This is an amazing day. I sat there thinking we are sitting in the room with our past, our present, and our future. I want to ask the adults today to do a favor for me. I'd like the adults in the room to stand and give an ovation to our future. I think we can't say it enough to the young people in the room that we are counting on you to finish the unfinished business of Brown versus the Board of Education. As we have traveled the country this year, most of the conferences, most of the dialogue has really focused on the unfinished business of Brown v. Board, what it is we know that's left to do. And we're counting on you to help move this country to the next step. So thank the adults in the room. I want to thank you for that ovation on behalf of our future. Now, Brown v. Board of Education. On May 17, 2004, Brown v. Board will be 50 years old. It will have been 5 decades since the Supreme Court rendered that now famous decision. I say that because according to legal scholars and according to historians, when events become 50, that's when they become true history. And without embarrassing anyone in the room, some of you all are pretty historic. But I'm in good company because I, too, am a member of AARP. And the good thing about that, though, is that with time and with experience, with history comes wisdom. So we're all far much wiser than we had been. As Linda indicated, we do a lot of traveling throughout the year, every year, but this year more so than others. And a couple of things I've noticed with all of the travel because of the airline industry really kind of going to smaller aircraft. A couple of words you never really want to see on your plane ticket, and all of you that travel very much will know exactly what I'm talking about. Those 2 words are the word link and the word express. Because you know that means a really small plane. And a couple of years ago, I was heading to Tupelo, Mississippi. Yes, the home of Elvis. I actually went to that little shotgun house while I was down there. But I was traveling to Tupelo, Mississippi by way of Memphis, and we walked out on the tarmac to board the plane, and the first clue should have been the propellers. Walked up the stairs on the back of the door, got in the plane, strapped ourselves in, the door closed, the propellers started, the propellers stopped. The doors open, in walks a woman with a clipboard. She walks down the center aisle of the plane. She turned around and looked at all of us strapped in and said something I'd never thought I'd hear. She said, "Where are you going?" Now, to true stories, truth is always stranger than fiction, but what she really wanted to know, because it was a small regional airline, she wanted to know how many people on the plane were also needing to stop at Meridian, Mississippi, so she could direct the pilot to make that additional stop. But I sit there thinking, you know, is it too much to ask that the airline know where you're going when you buy the ticket? But nonetheless, these things do in fact happen. Well, the legal name of Brown, as you've already heard, is Oliver L. Brown et al. Versus the Board of Education of Topeka, Kansas et al. We are encouraging people in schools, on university campuses, and associations around the country to really get to know who the et als were. People in the legal community already know that et al. Means and others. But the et al. In the case of Brown v. Board represents nearly 300 plaintiffs that make up that case from the states of Delaware, Kansas, Virginia, South Carolina, and the District of Columbia. 300 people are involved in Brown v. Board. What we hope you are learning, and will continue to learn as we work with textbook companies around this country, Brown was never about the Browns. That's one of those misnomers, one of those myths that we've had an opportunity to dispel as we traveled the country, and we hope you'll learn something about that today. But it's important to note that not only were all those plaintiffs involved, but more than a dozen attorneys and community activists around the country made Brown a reality, if you will. Also, when people talk about Brown v. Board, it's the Kansas that gets left off. You know, it's Brown v. Board. It's not Brown v. Board of Topeka, Kansas. Now, we know that Kansas is really not the first place that comes to mind when you think about diversity, and that's okay. But Kansas has been a critically important state to the civil rights history of this country. So also use this window to really take a look at Kansas. What was going on out there that made it so unique in our country's history? It was a state of Kansas that stopped the westward expansion of slavery in the history of this country. And it was a state of Kansas for some reason during the Brown era, where Kansas and Kansans were helping to lead the charge. Now, I have to ask before I go on, how many of you have ever been to Kansas? Okay, now the second part of that question, did you stop? Because we know a lot of people drive through Kansas. They don't really spend a lot of time there, but we want to invite you out on May 17 of this year for the grand opening of the Brown v. Board of Education National Park that will open on the anniversary day. And if you can't make it out in May, the park will be there in perpetuity. What the park is doing is interpreting Brown v. Board in the context of the African American experience in this country. Now, in talking about the history of Brown, first thing we have to be willing to embrace is our country's controversial past. Please understand that nothing in our country, with respect to segregation, denial of opportunity, racism, bigotry, or discrimination, none of those things have happened by accident. Unfortunately, it was all very intentional. Now, you only have to look at the United States Constitution, 1787, Section 1, Article 1, Section 2, Paragraph 3, that refers to people of African descent as 3/5 of a person. You only have to look at the Dred Scott case when the United States Supreme Court rendered its decision saying that African Americans had no rights that whites were obligated to respect. You only have to look at 1896 Plessy versus Ferguson. Separate was never intended to be equal. To know that where we find ourselves now is not by accident. Understand that first. Because what Brown v. Board of Education attempted to do was to bridge the gap between democratic theory and historic practice. Because the way our country espoused democracy and the way it practiced it with respect to people of color were two different things. Understand that first. See, on May 17, 1954, at 12:52 p.m., when the court rendered its decision, change started taking place in the hearts and minds of an entire generation of African Americans. That motto would later be used by the women's movement, citizens with disabilities, and disenfranchised groups around the world. Because within them, Brown created a vision of a democracy that would provide unobstructed access to political, economic, and social rights. Now, nobody really finds history, well, I won't say nobody, most of us don't find history all that engaging. But for the youth in the room, it is more than a cliche that if you don't know your past, you will allow those mistakes to be repeated. See, I'm of the generation that thought we were going to finish the unfinished business of Brown v. Board. You know, and some of my compadres are out there, you know, we walked around with the big hair and the raised fists, you know, and the attitudes. We thought we were going to finish the unfinished business of Brown v. Board. Had we known our history, we would have known that we were not the first Black Power movement in this country. The first Black Power movement in this country was in the 1850s in response to a fugitive slave law. There's nothing new under the sun. I say that because had Thurgood Marshall and Robert Carter and Jack Greenberg and Oliver Hill and Lewis Redding and the Scott family of attorneys and all of those attorneys involved in Brown, had our parents and all of the plaintiffs in Brown and the community activists just thought for 1 minute, they would have known that Brown would remain unfinished business. I say that because if you think back about the era of Reconstruction that's already been mentioned, when African Americans had just a glimmer of what it would be like to participate fully in this country's political system and communal structures. But Reconstruction ended with backlash, beatings, burnings, denial of opportunity, all sorts of abuses, fear-based, I believe. Had they remembered Reconstruction, they would have known that Brown would remain unfinished business. But the one wonderful thing that Brown did for the country immediately, it placed the issue of race squarely on the national agenda. We were no longer living in the United States of denial. We couldn't pretend anymore that everything was all right on the racial front, if you will. So African Americans began to ask themselves, if it is not legal to be kept separate in classrooms, how could it be legal in transportation, at lunch counters, in public accommodations, and even in the halls of Congress? You see, this summer, June 23, 2003, when the Supreme Court rendered its decision in the Michigan cases, it should have reminded all of us that politics, whether it's local, state, or national, absolutely determines who, what, where, and how we educate children in this country. During slavery, education was seen as a down payment on freedom. Education nowadays is a down payment on opportunity, without which you cannot expect to participate in this country's system by any stretch of the imagination. When people ask me, what is it about Brown that makes it supposedly one of the most significant legal opinions in this country's history, I believe Brown is significant for 5 very basic reasons. First reason, it was the beginning of the end of segregation sanctioned by law. Only the beginning, didn't end anything. Secondly, it overturned the laws on the books in 21 states, including Kansas, that either permitted or required segregated schools. Kansas permitted segregated schools, but only at the elementary level, and only in large cities. The Kansas law said that cities of the first class, 15,000 or larger, could have segregated schools, but only at the elementary level. So that meant in the entire state of Kansas, we were only looking at the city of Kansas City, Wichita, and Topeka, and only elementary schools. It's kind of a unique way the state legislature chose to deal with segregation. Third reason Brown is important is it overturned the previous Supreme Court decision in Plessy versus Ferguson, which gave us separate but equal. But it's the fourth and fifth reasons, I think, that are most profound. When the Supreme Court used the 14th Amendment as its pivot in deciding the Brown case, it really set aside the debate over states' rights. Because in essence, what the court did in rendering the Brown decision makes Brown important for everybody in this room, regardless of race, ethnicity, gender, disability, or any other condition. Because what the court did was it defended the sovereign power of the people of the United States not to have their rights arbitrarily restricted by state and local governments. Race was an arbitrary restriction imposed at the state and local levels, if you will, even before Plessy. The fifth reason Brown is important is one I think people seldom if ever think about. Because our country was in the midst of a Cold War during the Brown era. And the Soviet Union and other communist countries had started a propaganda campaign against the United States, suggesting, how dare the United States hold itself up as the moral voice of the world when it was engaging in human rights abuses right here. Our country needed Brown v. Board for foreign policy reasons. So much so that President Truman, at the end of his administration, directed his State Department to issue a Friends of the Court brief to the Supreme Court, giving them a nudge about rendering this decision in favor of the plaintiffs in Brown. And having it be unanimous wouldn't hurt either. So when Eisenhower got to the White House, one of the first things he did was to go on the Voice of America to broadcast to the world that the United States did in fact, or was in fact, starting to live up to its constitutional promise with respect to people of color. But it would be short-lived, this pronouncement, if you will. Because not too long after Brown, the country was back on the world stage with respect to human rights abuses, with the brutal murder of 13-year-old Emmett Till, African-American child, 13 years old, from Chicago, who had gone to Mississippi for the summer to visit relatives. 13-year-old Emmett was drugged out of his uncle's home in the middle of the night. He was beaten, murdered, weights tied around his ankles, and thrown in a river. Because at 13, he had done nothing more than to speak to a white woman in post-Brown Mississippi. We were back on the world stage for human rights abuses in this country. Our hands are not totally clean, if you will. Well, Brown v. Board can be thought about in terms of myths, challenges, and unanticipated consequences. The myth of Brown is what my sister and I spent an awful lot of time countering, and it's what the park will hopefully put to rest. Because the myth about Brown is that Brown was all about a little girl wanting to go to her neighborhood school. She could not because it was for whites only. Her father was angered by that and sued the school board, and that's supposedly Brown v. Board. Well, it's not, for all of you that have been laboring under the notion that that's the story. See, first of all, Brown was 105 years in the making. First legal challenge to segregated schools in this country was in 1849, even before the Civil War, Roberts versus the city of Boston. In that 105-year period between that first case and Brown, numerous cases were brought to court around segregated schools by Asian Americans, Hispanics, and African Americans as well. In our home state of Kansas, there had been 11 other cases before the Brown case in 50 to 54. First Kansas case was in 1881. There were two other cases in Topeka before the Brown case in 50 to 54. I say that because you need to understand that there was a lot of activity going on around this business of education, understanding the significance and importance of education. So in the fall of 1950, after 2 years of trying, when the NAACP, after recruiting families, as you heard Linda say, and our father in our family was the one that stood up with the group, NAACP had tried for 2 years to convince the schools simply to integrate. They could have done that at any time. So when they didn't heed his request, they decided to organize a 12th case in Kansas against segregated schools. So in the summer of 1950, families were told to locate a white school nearest to your home, take your child, children, and a witness, try to enroll, come back and tell us what happened. February 28, 1951, when the case was filed, that's when it became known by our dad's name, Oliver L. Brown. But for the ladies and young women in the room, listen carefully. Because when you look at the roster of plaintiffs in the Topeka case, went on to be the lead case, 12 women, 1 man, Oliver Brown. Set the myth aside that it was named for Dad because there was nobody on that list with an A in the beginning of their last name. No Andersons or no Ashcrofts. But set the myth aside because alphabetically it would have been named for a woman on the list by the name of Darlene Brown. Mrs. Brown still lives in Topeka. D comes before O in my alphabet. So had it been alphabetical, it would have been known for Darlene Brown and not Oliver. So the only thing we're left to surmise is that Dad was assigned that role because of his gender. because in the late 40s and early 1950s, men used to be all that, as young people say, prior to the women's movement. But nonetheless, for no other reason. Now, it doesn't make us any less proud of our legacy, but it certainly requires young women to really examine Brown and so many other things in our country's history. Because of those 5 cases, the majority of the petitioners were women. Part of women's history in this country. The other thing to note is that Brown, like the civil rights movement, was brought by young people. All of these were youth movements. You look at Eyes on the Prize, who do you see out in the streets facing down fire hoses and dogs? You see teenagers, people in their 20s. Our parents were young people. Martin Luther King was only 24 when he got to Montgomery, 5 years out of his teens. Mother was 29, and even though she'd graduated at the top of her class, she was settling into her role as a homemaker. Dad was 32, and like most African-American men of his day, simply looking for respect and fulfillment. He had tried boxing in the Golden Gloves. He went on to become a minister. And the joke in our family is that after Dad experienced the first knockout in the Golden Gloves, he was called into the ministry. But nonetheless, it's an interesting thing to know. Well, as I indicated, Brown talked about beginnings. I'm going to wrap it up so we can do some Q&A. Brown really undergirds all of the other Supreme Court decisions, transportation decision that came after the Montgomery bus boycott, Civil Rights Act of 64, Voting Rights Act of 65, Title IX of 72, all of those things that came after. Brown is the foundation of those. But before I close, I want to remind all of us that it is the challenges and how the country responded to Brown that's been most troubling. You see, we all know about the Little Rock Nine, the 9 brave teenagers who attempted to integrate Central High School in Little Rock. One of them has written a book called Warriors Don't Cry, Warriors as in fighting. It's an amazing book about what happened to them every day at school once those doors closed. But maybe not as well known is the fact that in Prince Edward County, Virginia, public schools were closed for 5 years rather than allow them to integrate. You have to wonder, how could public officials in Arkansas, in the case of Governor Faubus, close schools for a year? How could public officials in Virginia close schools for that long and get away with it? The reason is, and I would suggest you go on the internet and take a look at this thing, a document called the Southern Manifesto, that nearly 100 elected officials in the United States Congress got together and wrote this document saying that they weren't going to comply because the South was not unhappy. And the Supreme Court had overstepped its bound, and they were going to use any legal means at their disposal to overturn that decision. One of the people that signed the Southern Manifesto was still in Congress as recently as 2 years ago. Yeah, you know who it is. The birthday boy, Strom Thurmond. And he kept getting elected. I don't know what that's about. But I would certainly caution all of the youth in the room that are turning 18 and will get to vote in November to be really mindful of who you're voting for and what they really stand for, if you will. Well, I want to share a quick story, then read my list of unanticipated consequences to demonstrate how these policies have remained just under the surface. In 1968, when I got ready to go off to college, as many of you will in this room in years to come, I got a letter from my institution telling me who my roommate was going to be. It was a young lady by the name of Kathy, and it told me what city she came from. I didn't really think about it. I put the letter away, partied the rest of the summer before I had to get serious to go off to school. In August of 1968, I got another letter from my institution. I'd been assigned to a different roommate, a young lady by the name of Roslyn. She was from New Jersey. I didn't give it any thought. I just thought maybe Kathy decided not to go to school there. Well, in the fall semester, living in the dorm, I ran into Kathy. Kathy had decided to go to school there. Kathy was white. Kathy told me an interesting story. She said, you know, I got a letter this summer, too, telling me my roommate's name was Cheryl Brown. But it went on to say that Cheryl was black and asked my parents whether or not they wanted me rooming with a black girl. Now, some of us came of age during the Civil Rights Movement, watching Rosa Parks arrested on the bus, Martin Luther King, the Black Panther Party, Southern Christian Leadership Conference, the Congress of Racial Equality, the Freedom Riders. So I knew I had to do something about the story I just heard. So I got dressed. I went down to the Dean of Students, and I said, I heard an interesting story today. The dean was an older white woman who got very red-faced when I told her what Kathy had told me. The dean started shuffling papers on her desk because the roommate I ended up with was African American. She got ready to answer me, the dean did, and I held up my hands and I said, no, you didn't do anything wrong. You simply made a mistake. The mistake you made was not making certain the letter that came to my home didn't tell us that Kathy was white and asked whether or not I wanted to room with a white girl. Basically, if you're going to be stupid, be equally stupid. But it is important for everybody in this room to know that those policies remain just under the radar. And like it or not, some of those practices, fully intended, are still in place. November, we're going to elect another president. Every 4 to 8 years, new education policy on the ground. Brace yourselves, because it's inevitable. And educators, as we go through this anniversary window of Brown, we are asking people to recognize one of the most important professions in this country. That is teaching school. People graduate from high school and college and forget how they got there. They got there because of those educators in those classrooms day after day, doing their job. It is a mystery to me why we don't recognize them more. Hearings on Capitol Hill, I've never seen one on C-SPAN about public education. When are we going to take it seriously, if you will? We know how to educate children in this country. It's not rocket science. We know small class sizes work. We know having access to technology works. And we know the way we are doing it now, when we talk about failing, underfunded inner city schools, we are educating to ensure second-class citizenship again. Who are we kidding? We know these things. But when it comes to outrage and passion and commitment, the political will just is not there. Our system of government works exactly as we are taught. We seem to be the missing element. Being a United States citizen is not a spectator sport. You can't sit around watching. You have to be fully engaged and fully participating in what this country has to offer and how it operates. Last caution I would give you during this election cycle, because it generally comes up and comes out of somebody's mouth that the best thing for us to do is to return to the way it was during the good old days. Now, the good old days weren't good for everybody. I don't know what days they're talking about. But I read a book a few years ago by a family historian by the name of Stephanie Coons. And she wrote a book called The Way We Never Were, The American Family and the Nostalgia Trap. And Stephanie, in the beginning of her book, says something very profound. She says, Leave It to Beaver was not a documentary. It was television fiction. And she goes on to say that the social ills that are with us generation after generation have always been part of the human experience. Single-parent homes, nothing new. Teen pregnancy, nothing new. Substance abuse, nothing new. Certain amount of violence in this, it's been with us forever. I say that in the context of Brown because I think our young people have so much on their shoulders already. Let's not assign the responsibility of those ills to them. My generation was blamed as well. But rest assured that it's been part of our experience living in this country, living on this planet from day one. So don't take the rap, young people in the room. Keep looking, keep moving forward, if you will. We need you, and we need you to be at your best. Well, the unanticipated consequences of Brown, things that nobody could ever have envisioned. I'm sure Thurgood Marshall and the legal team in Brown had never heard the phrase white flight. Who knew that when public schools could open to all children, there would be a certain segment of the population in the white community that would simply pack up and leave the community rather than allow integration to unfold? Magnet schools, certainly not heard of during that era as a possible remedy. Reverse discrimination? First thing that does, like the old thumb pointing back at you, is an admission that there's discrimination. The Bakke case, who knew that was coming down the pike? But the most insidious of the unanticipated consequences are people who write these books every few years to try to suggest African Americans simply are not capable of intellectual pursuits and academic achievement. Books like The Bell Curve. Those books started cropping up in the 1800s, and I'm sure that's not the last one. Somebody today is probably working on the next one. But it's amazing to me how committed people have been to hanging on to their biases in this country. You know, between preschool and teenage years, children learn a lot of lessons. But the one lesson we need to stop teaching them is racism. Kids are not born with those thoughts. They learn them, and they learn those lessons far too well, if you will. State of Minnesota a few years ago did a survey about hate crimes and discovered that the majority of racially motivated hate crimes were committed by people between the ages of 11 and 21. What on earth does somebody that young know about me to want to hate me? We teach them those lessons well. No preschool child in this country raises their hand and says, when the teacher asks, what do you want to be when you grow up? Nobody at that age says, ooh, I want to be a bigot. They're not born with those genes. We need to be careful how we communicate to our youth and what we say in front of them when somebody cuts us off in traffic. We are guilty. We soiled them needlessly. Well, in closing, McKinley Burnett, who was the person in Topeka that organized the Topeka case, when he was interviewed about Brown, and then I want to do a quick little quiz with you, said, maybe now that the court has rendered this decision, maybe now I can sing "My Country 'Tis of Thee, Sweet Land of Liberty," without feeling like a hypocrite. Now I want you to raise your hands in response to this quiz, and then I will take my seat. How many of you in this room have ever ridden a motorcycle without a helmet? Okay. How many of you in the room have ever smoked a cigarette? Okay. How many of you have ever eaten fast food for 3 or more days in a row? Okay. How many of you have ever just called in and just taken a sick and tired day? Okay. Now on this last one, are your bosses in the room? Is that the problem? Okay. I thought so. On this last one, I want you to be really careful now. How many of you have ever told a lie? And some of you may be lying right now. Your hands aren't up. Now, every single thing on that quiz, everything that we just raised our hands to so easily, every one of those things require a certain amount of risk. So I am challenging you all to take the risk to get to know the person on the other side of that skin color, because that's the only way we're going to be able to finish the unfinished business of Brown v. Board. Thank you.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as Chief Prosecutor at the Nuremberg trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716 483 6646.